Now that every single person with money is going to be leaving New York and moving to South Florida, what are they going to be faced with?
What's interesting is that New York courts refuse to enforce Florida non-compete laws. So they need to change their contracts to make sure that it applies Florida law as opposed to New York law. And then once they do, they're going to realize that Florida is significantly more employer friendly when it comes to protecting legitimate business interests. It's terrible.
These people are potentially screwed.
It seems to me like it's an incredible abuse. What legitimate business purpose is that serving?
You sign a contract, read it.
And judges don't like telling people you can't work. You're being an ass. It's a bad look. It's extraordinary relief. And it's not a given that employees are going to lose.
Can you just explain to me what's going on?
You're incredibly naive. There are people that simply don't follow the law and are willfully violating the law.
That's it. They could bankrupt them entirely. And here's the most offensive part of it.
The frustrating part is when you have a small business that knows the law, tries to follow the law, does their best to follow the law, but then you have these opportunistic plaintiffs that are just lying.
I'm going to get a lot of heat for that.
Welcome back to Courtside. I'm here with Jose Ferrer and our colleague Yaniv Adar. I'm Eitan Mark, and we're here to talk about some of the recent legal issues that are occupying our brains.
Let's do it.
Let's do it.
Let's
get going.
So we brought Yaniv on because, Yaniv, let me just kind of kick this off. Now that every single person with money is going to be leaving New York and moving to obviously South Florida, can you talk to us a little bit about the non-compete landscape and what some of the businesses in New York are going to be contending with once they move down here with their employees, which presumably is going to happen in the next couple of years?
They will really be pleased with what Florida has to offer for a number of reasons, but specifically in the non-compete context, you're going to see that in New York, the presumption was that non-competes are generally invalid, right? That when you enter into a non-compete with an employee, it would be something that would be unexpected if you were able to enforce it.
And when we're talking about non-competes, why don't you just so what we're talking about is basically that you have an employee that is working for you and they're agreeing via contract not to steal your business effectively in the event that they end up leaving the company.
There's basically two big restrictive covenants that are enforceable. One of them are non-competition agreements, which means you can't compete against the company that hired you for a specific period of time. And the other is non-solicitation, which is you can't solicit the customers or employees that work there.
Okay, so then you've got all these people who are living in New York, they're moving down to Miami. What are they going to be faced with respect to the non-compete landscape? You indicated that it's more favorable for them.
It's definitely more favorable for employers in Florida.
Okay.
First, they're going to want to make sure that they change their contracts to have a Florida choice of law. What's interesting is that New York courts refuse to enforce Florida non-compete laws. Even if you're in New York, they just say as a matter of public policy, we're not going to do it. So they need to change their contracts to make sure that it applies Florida law as opposed to New York law. And then once they do, they're going to realize that Florida is significantly more employer friendly when it comes to protecting legitimate business interests.
You're assuming that it's more favorable because of people that are coming down from a company standpoint, but from
Correct.
an individual employee standpoint, it really isn't.
It's terrible.
And the issue that I have with non-competes and how they're enforced in Florida particularly is that, and I'm going to be the contrarian today, but it seems to me like it's an incredible abuse of the structure of a non-compete. And I'll tell you what I mean. Clearly in the tech space, you want to protect certain intellectual property rights. Completely justified to have that. Completely justified to have a non-compete agreement because you want to protect that. But I've seen it in the context of, baristas, right? Where a company doesn't want a barista to leave, or a coach at a gym. Like what legitimate business purpose is that serving other than using it as a client retention tool, which is terrible, right? I mean, you want people to be able to leave. You want people to be able to have gainful employment somewhere. And if you want to keep your employees, then, make them happy otherwise, not because you're holding them hostage. So that's a really big issue that I have with non-competes. And I'm going to get a lot of heat for that because we represent a lot of companies and we are certainly on the employer side of the V plenty, and we enforce these things. But in my opinion, unless you have a legitimate business interest to protect, these non-competes shouldn't be used as an employee retention tool. I mean, what do you think?
Well, look, unless you have a legitimate business interest, they're not enforceable in New York, Florida, or anywhere else, right? So there's this misconception that if you sign a contract that restricts your ability to compete, that it's enforceable no matter what. And that's not right. It could be if there's bad lawyers involved, right? But ultimately, if there's someone that signs a non-compete and there's nothing to protect, and the employer just wanted to be punitive to be able to keep them on their payroll, then courts should not enforce it. It's that simple.
Is there any sort of distinction between, so Jose mentioned a barista, right? So somebody makes a great cappuccino, that's not necessarily somebody that you need to protect, but maybe it is. I don't know. Where's the line? Do you know where the line is that the courts are drawing here with respect to what is the level of employee where it matters and a non-compete is going to be enforced?
So in other states, like in New York and Delaware, the level of employee matters, right? So if you're getting employee stock benefits or you're getting a payout when you leave, that's significant. In Florida, less so. But there is no line. I mean, that's what's the fun part of being a lawyer. You get to be able to tell courts what it should be. And ultimately, the question in the barista context is, did they learn something secret in terms of how to make coffee a special way? If you told them there was this amazing way to make coffee, or there was a special ingredient that you can use, then you should be able to protect that. But what's important is, even in Florida, you can only protect it, you can only enforce non-competes to the extent necessary to protect that something special. You can't simply say, I want to prohibit them from working or earning a livelihood.
So what does that mean? You have to have what? Geographic boundaries and I guess, duration boundaries, right?
Right. There's three factors that courts will enforce when it comes to non-competes in Florida. There's going to be time, duration, and scope, right? Or time, geography, and scope.
Okay.
So, but separate and apart from that, even when you satisfy that burden, you still need to be able to tell the court, I need to restrain this person in order to be able to protect something. And you can't enter an injunction beyond what's necessary to protect that thing. And Florida defines some examples of what those things are. Relationships with customers, trade secrets, confidential business information that doesn't rise to the level of trade secrets. But the ultimate restraint has to be narrowly tailored to protect the specific thing you're looking to protect.
But I guess to piggyback on what Jose said, right? So I want you to defend the company here, right?
Sure.
Okay, so confidentiality agreements are different, right, than non-competes. And there's a whole nother sort of bucket of claims that you could bring with respect to theft of trade secrets that really have nothing theoretically to do with a non-compete. So if you're worried about preserving customer relationships, for example, customer lists, et cetera, you can do that via, correct me if I'm wrong, a confidentiality agreement that says that you are, to maintain these in the highest secrecy, blah, 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 blah. So it's whether it's, how to make a cappuccino or a customer list, those are going to be protected, okay? What I think that what is sticking in Jose's craw, and I kind of get it, is that you've got these employees that are not represented by counsel when they're signing these employment agreements, right? And then one of the provisions of this employment contract is that if you leave the company, you can't compete with us for 2 years in this marketplace. Well, these people are screwed, right? For 2 years, these people are potentially screwed because they can't make a living anymore, right? So why is it not enough, as a matter of Florida public policy, that a confidentiality agreement or a trade secret, some kind of prohibition on trade secrets, why doesn't that get you there? Or is it just that Florida is so business friendly that it's just kind of like tough shit?
Well, first of all, the policies that you're advocating are really friendly in New York, and something that there's reasons
well, I'm
why
not going
people
to New
are
York.
moving
Dude.
down
I'm not going
Florida
to New York.
to avoid this type of
We're staying here.
policy that you're advocating.
My
right?
kind is not welcome in New York right now.
Fair enough. So there's different statutes that protect trade secrets, right? There's federal and state statutes that are specifically governed to that. But I think the problem is, for employers, is that trade secrets is something that's very specific, and there's a very high threshold that you have to meet to be able to define a trade secret. You asked me to advocate on behalf of the company, right? If I run a company and I'm going to hire someone, before I invest the time, energy, and money and share my business expertise with that individual, I want to make sure that they're going to enter into a contract that's going to respect what I've worked and spent millions of dollars investing. So yes, you have the ability to protect trade secrets through different statutes, but for non-competes, if you're able to define, this is the secret sauce, or this is the confidential information that makes my business special, even if it doesn't rise to the level of trade secrets, you have a right to protect that. And if the employee doesn't like it, this is a free market. They don't have to sign anything so long as it's transparent. And courts will look at agreements to make sure that the employee understood what they were signing at the time they were signing it.
Yeah, that's a tough, I've been down that road before where I've litigated that issue, I'm sure Jose has as well, where you're dealing with unconscionability claims and you're claiming that the employee didn't know or should have, that the font was too small and they didn't see the backside of the contract or whatever it is. Those are tough claims for an employee to bring.
Yeah, but the employee, a lot of people think that it's really hard for an employee to avoid getting enjoined pursuant to a non-compete agreement. And I think that's incorrect, right? So ultimately, the best way to attack non-compete agreement, if you're an employee, and I work on both sides, I represent both employees and employers because I feel comfortable doing so, is the relief that they're seeking, the way that they're seeking to restrain an employee is not necessary to protect the secret sauce they claim they're protecting, right? So for example, if someone is the barista example, if they're making coffee and they learned how to make coffee a very specific way and they want to go be whatever the barista equivalent of is of a tea maker, right? And they want to go sell tea, they shouldn't be restrained to be able to sell tea because it's irrelevant in terms of what protection the employer wants to protect their confidential information.
Yeah, it puts these employees in a tough spot though, because what ends up happening is that you've got, and we, again, we represent companies typically that are seeking to enforce these covenants, and every time that we're representing a client that's trying to enforce these covenants, our client's always right. There's always 1,000%. They're like, of course, they're always right, and it's always the employee's fault because they're scumbags, and that's just, but that's a separate conversation. But in this particular case, where you have an employee that is on the wrong side of a complaint, where a company is suing them because they want to get an injunction or whatever, then that employee may have to go out and pay 40, 50 grand for a lawyer to defend them to fight back against this injunction, to argue these issues relating to scope. It's a tough and unfortunate situation.
To the point that Florida is so friendly to employers in non-competes, it used to be, it was undefined in Florida whether an employee who signs an agreement that doesn't have a non-compete, and then after they're employed, the employer comes back and says, hey, by the way, we want to enforce a non-compete, or we want to have a non-compete provision, whether that was enforceable, because it goes to whether or not that employee had a choice, especially after they're working.
Right.
In Florida law, the cases came back and they said, yeah, that's okay. That's okay. You could force an employee to sign that. And I'm not against non-competes by any means. But when I'm representing clients, companies that are seeking to enforce non-competes, I start by advising them on the drafting of those provisions, right? Be reasonable. I think that, if you're running a pharmaceutical company, for example, you spend billions and billions and billions of dollars developing those formulas, the secret sauce, like you said, for that medicine. There should be a protection. There should be a protection for those people that are subject to that recipe, right? In the tech space, that's the perfect example. You're developing systems that are new, especially with AI and everything that's going on. You should have a protection. But, if it's the barista, and I keep on coming back to that because it's the most obvious example, and in my mind, the most flagrant, or, a 22-year-old coach at a gym that wants to go somewhere else, I don't think that's reasonable. Right. I don't think that's a reasonable restraint.
Right.
I just don't.
What happened with the FTC? A few months ago, there was all this noise about how the FTC is going to get rid of non-competes. That did not pan out, correct?
So the FTC is an organization that when they determine how they feel something should be, they act on it, right? And when there is a Democrat in the White House, they're enabled to do that. So when Biden was president, he enabled the FTC to be able to say that if you want to determine that all non-competes are, as a matter of public policy, unfair and deceptive, you can. And they passed a regulation, or tried to, that said that non-competes are presumptively improper under the FTC Act. And it looked like it was going to go into effect, but the courts stepped in, entered an injunction delaying their enforcement. And then when Trump took office, he said, I'm abandoning all this altogether, which is unsurprising considering how generally he's more pro-business than.
If I'm a New York business, does it matter where the employee is situated in order for which non-compete law, state's non-compete law is going to apply?
Yeah, it does, because if the employee has no connection to Florida whatsoever, then it could be difficult or a challenge to be able to enforce Florida law. You can't have a Wisconsin company employing someone in Idaho saying we're going to enforce Florida choice of law and you have to go to Florida. That makes no sense. But, companies should have frank conversations with their employees, say, we are moving to Florida. And I think to your point about being reasonable, just explain to them that in Florida, we are happy to pay for your relocation and happy to have you come down here and work for us, but there's going to be an expense associated with that. And we want to make sure that you don't screw us. I mean, for a large part of this dialogue, you guys have been defending the employee. Again, I think it's important, even though I have defended employees, that the employers, they wouldn't exist if employees could just simply come and go as they please, or employers wouldn't want to hire individuals if they knew that there was a good chance that the second someone offered them a little bit more money after getting all the training and benefits,
that's true too. And also, it's a little bit of, you sign a contract, read it, know what you're getting yourself into, and if you got to spend a few bucks to hire a lawyer to advise you on whether or not, the scope is reasonable or whether or not this is going to ultimately screw you at some point in the future, hire that lawyer and get that advice. I mean, at a certain point, employees need to be responsible for what they sign.
There is one point though, you mentioned that if someone gets sued, they have to be able to hire an attorney to be able to protect them. One of the things I've found as someone who regularly enforces these non-compete agreements, that there is a third factor of someone that protects the employees, and that's the judges, right? So even though Florida law is more employer friendly than other jurisdictions, there's still protections in place. And judges don't like telling people, 22-year-old baristas, you can't work.
Right.
It's very
Right,
it's very
of course,
challenging.
yeah.
So the burden is always going to be on the employer to be able to convince the judge this is fair, and ultimately the big term is equitable.
I also think that if you're in a position where you're being asked to sign a non-compete, that is that you have particular training or expertise that justifies somebody restraining you from working somewhere else, then you should be able to negotiate better terms for yourself, right? If it's the barista, the 22-year-old coach, I don't know that they have much leverage because they're a dime a dozen. But if you are somebody that has an engineer, for example, that's designing systems, then you should be able to say, okay, well, let's come up with something reasonable that is going to protect your interests, company, but it's not going to inhibit my ability to go somewhere else if it doesn't work out.
Yeah.
Right?
And also, you mentioned earlier that whenever we represent employers, obviously the employee is a scumbag and we have to be able to do what's best for them. That's not necessarily true. I often have frank conversations with my clients saying, you're being an ass, right? Like, it's not a good look for you. And I think part of our job is to be able to counsel our clients saying, even though you might win, you shouldn't go after it.
Right.
It's a bad look.
Right.
So what are the limits? You're talking about, what is it, duration, scope? Where is the line?
Geography.
There's statutory guidelines that exist, but ultimately the question is, I think, whenever an employee is facing a non-compete lawsuit, is the relief sought necessary to protect the thing the employer claims they need to protect, right? So if they're saying that there is a specific training that they gave to the employee and they're telling them they can't work anywhere, even if it was allowed pursuant to the duration, scope, and everything else, courts aren't going to enforce it because it's not necessary. Like, let's go back to the fundamental rule for injunctions. It's extraordinary relief. You're asking the judge to do a pretty big thing that's out of the norm. So there are protections in place, and it's not a given that employees are going to lose.
And generally, because I remember that there are actually some specific guidelines in the statute, right? Like you mentioned, so if it's less than 6 months, it's presumptively reasonable. Mm-hmm. If it's more than 2 years, it's presumptively unreasonable.
Except for trade secrets, right?
Except
when you
for
get into
trade
trade
secrets.
secrets, then the courts say it's significantly longer.
As long as you can justify it, reasonably justify it. I mean, that's really the standard.
Is
it reasonable?
There's some variation depending on who the actual employee is, whether it's 2 years or 3 years, or there's one for 7 years, one for 10 years. But yeah, it's all in the statute.
So if you're advising a company, a startup, a founder, and they want to have a non-compete agreement, so what do you tell them about those limits? How do you begin to draft it so that it's enforceable and it's reasonable?
So you look at how other courts have enforced it. You want to make sure that when you go in front of a judge, you're able to tell them, every judge or most judges that have gone in similar situations have enforced it. That's always a good start, right? But the number one thing I would tell clients is change the choice of law from New York to Florida if you want to be able to protect your interests.
And I think it's also the other advice that I tell clients here is just let's focus on what you need.
Yeah.
Not what you want, right? This isn't about making it as onerous as possible.
Yeah.
What do you really need here? And then once you can kind of articulate what that is, then all of a sudden, usually you're in the world of reasonable
Yeah, it's the don't be a pig test, right?
exactly.
Don't be a pig.
Yeah.
Don't try to do more than you need.
Yeah. Let's pivot to the fact that I'm getting 5 million text messages a day because it's election season and it's driving me absolutely crazy. I know that talking about text messages is not the sexiest thing in the world, but it feels important right now for me personally. So here's my question. You do a lot of this work relating to defending companies that get sued for violations of what's called, I think, the TCPA, right?
Related statutes, yeah.
Which is one of the statutes because they're sending out these mass text messages. I thought that like 10 years ago, I signed up for something called the Do Not Call list.
Yeah.
And I thought that the idea was that's going to stop the spam calls and that's going to stop the spam text messages. That obviously didn't work. Okay. So what the hell is going on here? Can you just explain to me what's going on?
Well, first, you're incredibly naive, right?
Yes,
That
well,
the government
that
was going to be
granted.
effective in
Sure.
accomplishing something
I signed up on the website.
Right.
I don't understand.
So what's going on here is that there are people that simply don't follow the law, right? So the biggest problem with the TCPA is the Telephone Consumer Protection Act, right? It's a statute that was passed in 1992 where Congress said, we want to punish those that are disrespecting telemarketing laws.
And it's like robocalling is what it was,
Well,
right? In the 90s, it wasn't text messages.
That's a good
It
point. In
wasn't text.
1992, text messages didn't exist, right? So they just want to protect Americans that are eating their dinner, having their ham at the Christmas table with their families, and they're getting phone calls at 6:30 p.m. during the dinner hour that's appropriate to eat. And one congressman got called. He's like, this is outrageous. And they passed a law, right? So the reason why you're getting these calls is because there are companies that are generally hard to find and hard to collect that simply don't care and are willfully violating the law. And generally, if you're getting 5 million calls, 4,999,000 of them are going to be from people that are either overseas or untouchable by the government.
But hold on a second. Like, theoretically, I know who is calling me or texting me because they say, right, this is a campaign in support of so-and-so, right? Or click here to, reduce credit card debt, whatever it is, right? So if I click through those things, like, I'm getting to a company at the end of that. So is it really as simple as like, these are not all scams. These are actually companies that are standing behind this, that are communicating with me on a regular basis. Should I just be filing a bunch of class action suits against these companies?
Well, first of all, filing, and Jose has a thought on this, I'm sure I'd like to hear. You don't necessarily need to file it as a class action. You can just say Aton Mark is frustrated and suing. There's a private right of action.
Yeah, but it's more fun.
And there's a
to do.
penalty per text or per unsolicited call. What is
it's
it, $1,500?
$500 to $1,500 per communication. So you'd be a trillionaire under your math.
Yes, I
if you
would
could
be.
enforce, right.
So this is an example of a law that was well-intentioned but poorly implemented.
Yeah.
Because I just heard you say that the vast majority of companies that are engaging in this solicitation are not here. They're foreign and untouchable, okay? I get it. I get that people want to protect their privacy. I mean, we carry these devices into our bedrooms, into the bathroom. I know you do because that's when you text me.
I don't know.
Not judging.
How do you know when I'm in the bathroom?
Well, you're texting me. But so we take these devices with us, and I understand that there is an interest in kind of protecting that privacy aspect. But this is a law that has been used, co-opted, and I'm going to take a lot of heat from this because most of the work that I do these days is plaintiffs oriented and a lot of it is class action oriented. But it's a law that's been co-opted, abused by plaintiffs' lawyers who are now threatening the very existence of small companies. We had a case, just by way of example, because you handle this all the time, and I think you're being modest by saying that you handle these cases. You are one of the leading attorneys that handles the defense of these cases throughout the country. But we had a case a couple of years ago. This was a husband and wife who scraped together every last penny to put together a gym business. They had one gym, then they had two gyms, they had three gyms. And I mean, this has taken every ounce of just being that they had, not to mention the money that they put into it. They hired an outside service to send these text messages. And this one guy got one text message, he said, stop, and it didn't stop, and he got three more. Okay? So under the law, it should have been enough because there should be a penalty for that. Mm-hmm. If you're intruding on my personal space, my personal time, coming into my bedroom or my bathroom time, whenever it is, on my phone, there should be a penalty for that. I didn't ask you to do that. It should have been enough that for those 2 or 3 additional text messages, they were penalized $1,500. That's fine. But what happens is these cases are being brought on a class-wide basis. So now it becomes existential because this small mom and pop that, by scraping together, they've managed to have some level of success, now is facing a class action.
Yeah.
That's it. They could bankrupt them entirely.
It
will.
Every single time, at least not every single time, I shouldn't say that, but the overwhelming majority of the time that I'm representing these companies, the class action threat is existential and it will bankrupt them. It's not academic.
Yeah. So, and here's the most offensive part of it. Through discovery, we were able to get the engagement agreement between the attorney and the class rep. And by the way, this class rep files the same case over and over and over and over with this one attorney. The class rep was getting $2,500 no matter what the recovery was. The attorney was going to get the rest of it, right? So now you think about it. What's the
right.
What's the point of that?
Right.
This isn't
who's
solving.
Benefiting?
Yeah, who's benefiting? So
Yeah.
this isn't solving a greater problem.
No,
this is just penalizing a small subset of businesses, and it is existential. I mean, we've worked on some of these cases where you say you got to reach a settlement. It's distasteful, but you got to do it because it's going to bankrupt you.
No, you have to. I mean, and those kinds of I tend to agree. I mean, I think these kinds of plaintiffs' cases are what give lawyers bad names. You know, I mean, the ADA space is the
there
same,
you go.
Right? The ADA space, same kind of example, right? Where you've got this sort of cottage industry.
Yeah.
I think the majority of the cases filed in the Southern District of Florida, or close to the majority, are ADA cases. Okay, that means the federal judges, a huge percentage of their caseload, maybe not half, but I would say close to half of their caseload is ADA cases. And these ADA cases are ridiculous. Mm-hmm. Okay, this is not examples of where somebody is truly unable to use, the facilities because of some kind of a miss on the part of the construction or whatever. These are cases where you have a guy who has some kind of a disability, who is going from restaurant to restaurant to restaurant, trying to sue them,
Singling them out.
trying to find whether or not the rail is 4 inches, to the left, or whether or not the ramp is a little bit too steep, or whatever it is. And unfortunately, these cases also, they're just forced the party to settle.
And mind you, in the ADA context, those repairs should be made.
Right.
Obviously, we want those repairs to be
Yeah,
made.
and I think both statutes serve valid purposes.
But those aren't class actions, which is, so usually the ADA cases are not existential to the same extent that the TCPA cases
Well,
are.
but talk about that. I mean, why is it existential? We've been talking about it as if it's a foregone conclusion, but the people that are going to be listening to this may not understand why.
So there's the TCPA, the recent trend has not been to hold companies accountable for their direct actions, but to hold them accountable for anyone that's involved in their product through vicarious liability. So someone that they might have contracted with, or someone that might have been trying to sell their product, unbeknownst to them, made hundreds of thousands of phone calls over a period of time. And if you certify a class, then the court will say that you could be liable as the benefactor, even though that's not the standard, for $1,000 or $1,500 per phone call. So we're talking about hundreds of millions of dollars, billions of dollars in many instances. And what really drove the plaintiffs bar to focus on these as class actions is because after the law was amended in 2013, you saw eye-popping settlements, 9-figure settlements, and it becomes existential for even the largest company. But going back to the example that you gave is not even the most frustrating part. The frustrating part is when you have a small business that knows the law, tries to follow the law, does their best to follow the law, but then you have these opportunistic plaintiffs that are just lying. They go out there and they will use VPNs to be able to include cell numbers that are impossible to trace to them. They'll include email addresses that give just enough information to go past the safeguards in place to allow companies to call them and say, that wasn't me. And even though the person has all these safeguards in place and they probably will win at the end, even if there's a 10% chance they lose, 10% of $100 billion is catastrophic. So inevitably, it leads to recommendations to ultimately settle.
Yep.
I mean, in the case that we were talking about, this gym case, it was 3, if I remember correctly, 3 text messages, and the opening ask by the plaintiff was $500,000. It's like $500,000. What are we talking about for 3 text messages that clearly were in violation of the law? But that's a frustrating part. So if you're representing a company, what are you advising in terms of that type of advertising? That is text message advertising. Does it apply only to text messages or also to emails, or what's?
Well, arguably, it doesn't apply to text messages right now because the Supreme Court did away with something called the Hobbs Act a few months ago. So the whole TCPA landscape is again uncertain. So whether or not it applies to text messages as of today. It could not. It depends on the judge that you're in front of. But let's just assume that it does, right? Yeah, look, at the end of the day, they get sued, and I treat all my clients as if like they're...
But before they get sued.
Yeah.
So before they get sued, a company comes to you and they're like, look, we need to market. That's how we get our business. We need to do it on a mass scale, all right? What do we do?
The hard reality is I have to tell them, what do you think your ROI is going to be? And unless you think it's going to be insanely profitable, it's probably not worth texting because of how abusive TCPA and related statutes have become.
Are you protected if you hire a third-party vendor?
No.
Why not?
Even if you have a contractual protection, you're only protected to the extent that they're collectible in that contract, right?
Can you get insurance for this?
No. I mean, maybe, but I'll tell you that there was a time when you can get insurance, but when everyone was getting dinged for 8- and 9-figure settlements, the insurance companies say no more. And I'll tell you that unlike any other statute that I've seen, if you were to look at your insurance policy for any business or policy, you will see a carve out for the TCPA 99% of the time. It's gotten to a point where the plaintiff's attorneys, they'll ask for it because they have to as part of their initial disclosures, but they'll be shocked if there's any coverage.
Right.
It's very rare.
Well, that makes sense. That's why doctors go without insurance nowadays, right? Because they don't want to encourage malpractice type lawsuits.
I know law firms that go without it too.
Yeah.
All right, Yaniv, well, look, thank you, man. It was really good
course.
having you on this Courtside, and we're going to have you back soon. So thank you.
I appreciate that. Thank you.
Thanks. So I guess on the next episode of Courtside, we're going to be talking about big cases, Cardi B, Boeing, and the impact of when those cases and when celebrity cases collapse under scrutiny, for example, and what kinds of things you could be doing either on the plaintiff side or the defense side if you were representing companies like that in similar lawsuits.
Give us a follow and subscribe to our Courtside podcast. We'll have a lot of fun stuff on it.